Meeting is called to order. Good morning. This meeting is called to order. For the record, the time is 11:02 a.m. on March the 18th, 2025. Commission and staff are appearing from Helena, Montana in the Bollinger Room of the Montana Public Service Commission. I am President Brad Molnar. I'm presiding over this meeting. Please join me in reciting the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation.
For the record, the following commissioners are present. We have with us today Commissioner Wellborn, Commissioner Pinocci, myself, President Molnar, Vice President Fielder, and Commissioner Bukacek. The quorum is satisfied because all 5 commissioners are present. Is there any public comment? Are there any public commenters? Seeing none, do we have any online commenters?
Hello?
Please state and spell your name for the record.
Yes, this is Renee Pertz, R-E-N-E-E-P-I-R-T-Z, Renee Pertz from Prairie County.
For the record, you're saying that your name is properly pronounced as Renee?
Yes.
Thank you. Renee, please proceed.
But first, I just would like to, I guess, make a request, or maybe a request, I don't know, for today or for the future, is to be able to make a public comment before is nice, but also after. If I could request the consideration of the board to consider doing that, it's a lot easier after we've heard what you've had to say. So I would request that. One of my main comments, and then also I know that energy has been a hot topic in Montana, especially eastern Montana, and I would like to just make the comment, as we're looking at different energies, and there's quite a few of them, that we would be considering as MDU, which is one of the main energy providers over here, that we would be looking at the cheapest energy that we could, that would make the least footprint on our land, which is not wind. Wind is one of the most expensive, and you have to reclaim the land back to its original, restore it. I think that is in our Constitution, and we have to relook that, which would be very challenging with wind. And so I would encourage the commission to look at these other energies that MDU and other companies should be looking at. I mean, nuclear is there also, which is expensive, at least the first go around, but I believe Idaho is finding a way to do that, as Wyoming is looking at also. And so I would just comment on that it seems that, and I was going through some old hearings, and MDU itself said that they could keep on going as long as they're getting the tax incentives and the government incentives and tax abatements and all these things at 80%, which is huge, that they can keep on going. Can they maintain on their own? No, not without these. And I don't think it's a level playing field either. If you look at coal industry, I believe there are new coal turbines that could be installed that would create even more energy. They certainly don't have take the land up that this wind does. And it's absolutely devastating ag farmland and grazing land and all the other conditions and health conditions. It seems it seems that wind has received a free pass as far as just being able to take over the land. That we've never seen that happen with these other industries, with the loops they've had to go through, permitting, et cetera, et cetera. So I just asked the commission as they're looking more into that. I don't know what is on your agenda today, legislative things, I believe, but to keep that on the top of their mind. It is somewhat insane that we are looking into the most expensive, because we're getting taken on so many ends of this. The ratepayer is on half, and we pay for all those incentives. And then for the price hike, it doesn't bring anything to the state of Montana. Anything. It devastates our property, and it raises our taxes, and it lowers our value, actually, of our land. And I think that we're doing this because Washington and Oregon have passed laws to go green. Why are we paying the price for what they've done? Why are the landowners paying that price in so many ways? So I would just ask for that to be considered. And I thank you very much for your time. And again, I would just request that we could call in and be timely, which I probably have not been, and be timely on being able to make a comment after you've spoken. So thank you very much.
Thank you, Ms. Perch. Are there any other commenters online? Seeing none, we'll move on to our regularly scheduled work session items. Is there a motion on the commission meetings for the week of March 10th, 2025?
Mr. President, I move approval of the commission minutes for the week of March 10th, 2025.
We have a motion for approval. Is there a second?
I'll second.
There is a second. Is there any discussion? Seeing none, all in favor say aye.
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 And those opposed, same sign. None. The commission minutes for the week of March 10th, 2025 are approved. Next is our legislative update. Trevor is with us. Trevor, it's yours.
Mr. Chair, committee members, Mr. President, commission members, my legislative days flash back to me there. Not a ton has gone on in the 2 legislative days since we last met, but happy to report that the first of our legislative agenda bills passed on second reading yesterday. That was Senate Bill 22, which extended the deadline for hearing in Class D garbage hauler cases from 60 to 90 days. I would anticipate that to pass on third reading today and be through to the governor. By way of future meetings, there isn't a ton scheduled in the energy committees that are, straight down the barrel of your purview. There are 2 nuclear waste handling or nuclear fuels handling bills scheduled for the 27th next week in Senate Energy. We didn't catch those up on the first house, largely because, again, those are citing bills in Title 75 with DEQ, but wanted to put those on your radar because I know there is some interest among commissioners in nuclear technology in varying degrees. The one thing we do have on the books in this next 2 weeks is Friday, and that is the hearing for the Budget Subcommittee D section bill. Basically, the product of Subcommittee D is now in House Appropriations. That meeting is on Friday at 2 p.m. in room 102. That's the first of 2 opportunities for us to publicly comment on the budget and make the case for that docs processing position we discussed last week. I've put some calls into members of Approps to talk through that. I'm getting a pretty good sense that we're probably okay with that docs processing position. Again, Approps is kind of a rough neighborhood sometimes, so we'll see what they do in the House, and if they don't do it in the House, we still have another shot in the Senate in finance and claims. So with that, that's really your update as far as what's happened in the 2 legislative days we've had since last Tuesday. But I do know there's some discussion that was requested of me regarding the two larger bills we've talked a lot about, where they're at and what's going on. Those being Senate Bill 301 and House Bill 490. Senate Bill 301, again, is the transmission pre-approval or rate-making bill that we had questions last Tuesday as to whether it was alive or dead. And as we said, you never declare anything dead. The rules currently, upon my further review, do state that if OBPP puts a fiscal note on a bill, it becomes a revenue bill. So Senator Zolnikov has some more time, and at the hearing yesterday has voiced a want to continue to amend this bill. And talking to him briefly a bit ago, what that's going to look like is actually potentially a deletion of section 3 of this bill that you have in front of you, in which then the utilities would rely solely on a certificate of public necessity. So what does that mean for you as commissioners? Largely, if the bill takes that form, the new function would be to hold a proceeding in which you would consider granting that certificate of public necessity. It would still fulfill those initial stages of MIFSA. Basically, if the commission grants in a hearing with a full docket and full evidentiary record, that certificate, it does make it quite a bit harder for you to deny cost recovery for a transmission project down the road. I don't think that this would be the end of this discussion. I think this is a measure of the utility recognizing that maybe they need to have a deeper discussion with us regarding what a rate recovery mechanism would look like. And I would say that the position that puts us in, and again, that language isn't solidified, but striking that pre-approval process would leave you in the position of approving a certificate and then determining cost recovery at a later date. It would open the door to you setting your own cost recovery mechanism for transmission as part of that certificate proceeding. But the important thing to note is, cost recovery pre-approval aside, the process by which this bill operates now leaves all the discretion with the commission as to what you're going to do or not do in regard to the actual cost recovery of transmission. So I think what I would say, to sum it up, in this bill's initial Senate hearing, Commissioner Molnar and I made known that we had several questions. Most of those were answered. One of those remains outstanding, and that is Commissioner Molnar's want to find a definition for which customers, who's a customer, and who qualifies, as far as who might be on the hook for recovery. But I think the mechanism of this bill is changing to the effect that that might not matter anymore once we see round 3's new language. So there's the spiel on that one. We could do questions now or move on to HB 490. It's up to you.
Well, it's up to you. Do you anticipate questions on the other bill as well?
Probably. So let's
Okay,
just roll through
let's do
490.
questions now on this one, so.
Okay. House Bill 490 is the wildfire liability bill.
No, if you
Oh,
think we're
okay.
gonna have questions on both of them.
Yep.
Would you be comfortable with Commissioner Pinochi asking a question at this time?
Yeah, of course, of course.
What did Robert's rules say about that? Okay, go ahead.
Thank you, Mr. President. And I do have questions on 490. The two bills, in a way, coincide with each other. So let me ask you, well, first I should let everybody know that the fire risk portion of the bill has kind of been stripped away in the last few days. I'm pretty disappointed about that. But does the commission have the authority when we're looking at new transmission to raise the standards of what a distribution or transmission line can meet? Do we have the ability to work with the utilities on that?
I would argue, Mr. President, Commissioner, you don't have the statutory authority. There's no threshold set in statute. You could compare transmission projects and decide that one with a more modern technology is more prudent in that situation or not. But you're making a cost decision. There's no technological threshold in statute.
The problem with this is that we had a fire risk meeting here to explain the new technologies that are available and they're being installed all over the world. And what was made very clear is that when we use a steel core conductor, we're in fact using the less reliable, the less safe, the more expensive option. So to put transmission up without encouraging or raising the standard, I think is the whole purpose of the bill and why I was involved and why we even had that meeting. If we don't have a say in raising the standards, then we're going to be basically possibly installing old technology that won't be safe, reliable, or affordable. And I think that that meeting proved that point exactly. We have to start looking at encouraging the use of the new technology to reduce fire risk, encourage line loss where we could cut it up to 40%.
If I might, is there a question in there?
Yeah. So how can we get that put back in there?
Mr. President, Commissioner, it would take an amendment and language surrounding a threshold set for what types of transmission lines are acceptable to the legislature.
So we passed a bill a couple of years back that said we have to meet at least a 10% energy savings threshold and line loss. And everybody agreed on that. Now, the question is, and you already answered it, that we don't have any say in what the new standard should be or what kind of line we use, but we still have to approve and work with them on transmission when it's installed. Is that correct?
Mr. President, Commissioner, situationally, yes. I mean, case by case, it's going to be different, but you know, you're going to treat a transmission project currently in regard to rate recovery in likely a rate case and make a determination as to the prudency of those expenditures based on the proposal in front of you.
All right. If our goal, and I think this is important that I encourage the other commissioners to understand this, if we're going to take part in approving new transmission, and we have a goal on one side of our desk that says safe, reliable, and affordable, then the whole point was to say we've got to meet these new standards to reduce fire risk, encourage energy efficiency, meet decarbonization goals, because if we can cut line loss up to 40%, we're meeting these goals. The ability to cut fires in half will save millions of dollars and lives. If they want us to be part of the team of saying, okay, we're going to approve this new transmission, then I think we've got to be able to say, if we're going to approve that, we're also going to say we're going to improve the standards of which transmission needs to meet. So with that, I encourage this commission to say that, you know, we've got to, if we're going to play a part in improving the transmission, we get to play a part in saying, here's the new standards we have to meet. It's kind of like, are we going to build a car without an airbag? Airbags save lives every day. And if I'm going to be on the team to say, okay, we're going to have a new car go into production, it's going to have airbags. It's going to have anti-lock brakes. It's going to have all the safeties that I think need to be required. If you're saying that I can't do that, but I'm going to still approve the transmission, I'm going to say, I think we should have a concern about that. So that's my question. And what can we do about it? And I'd love to hear some other commissioners' input on this.
I think the answer was you'd have to amend it into the bill. because we don't do that just on our own, not unilateral. So any other questions or comments on, on Senate Bill 301?
Mr. President, thank you. So Trevor, thanks for putting this amended version in our binders today. A lot of the amendments solved many of the concerns I expressed before with the legislation. There's still a couple things though. I'm on page 3 of it, and at the top, the very first paragraph on the top of page 3, says the commission shall determine within 300 days whether the construction of the proposed transmission facility is in the public interest and may grant or deny the certificate of public convenience and necessity. So I see that was increased from 270 days as originally drafted. But then that section 3, if you look at paragraph 3 in section 3, it says the commission shall issue an order within 90 days after receiving an application. So I think those, am I reading that correctly, that those two numbers are at direct odds with each other?
Which line are you on the 90 days? Commissioner?
The 90 days is down in near the bottom of page 3, and it's paragraph number 3.
Oh, Matt, Mr. President, Commissioner, you aren't reading it wrong. However, these are two separate processes that are in this bill. So this initial process is the process to gain an approval or denial of a certificate of public necessity. Once that happens, or doesn't, but if it happens, then you move into this process laid out in section 3. So you would receive an application for cost recovery in this section 3 in a semi pre-approval process. And that process would then have a 90-day deadline. The process to attain the certificate of public necessity has a 300-day deadline. And I think the thought process there is, if the commission has gone through a process to determine a certificate of public need or necessity, and it had 300 days to do it, we probably have a pretty strong evidentiary record going into the cost recovery determination, which in their view would loop in the record of the PCN proceeding. Now, like I say, I want to point out, I just got word that this section 3 substantially is just going to go away now. So really the process is the 300-day PCN for what it's worth.
Okay, I'll follow up, Mr. President. So Trevor, then would it be correct to say that really the effect of the legislation, if section 3 is removed, would be to have the commission review a transmission line, and if we find that it meets PCN requirements, that then the transmission line would not be subject to facility siting under Title 75, Chapter 20.
Mr. President, Commissioner Fielder, not entirely. There is still quite a bit that goes into the MIFSA process. What it does exempt a project from under MIFSA are the initial stages in which they too have to find a public need for the project in order to proceed.
Okay, thank you. I appreciate that. There's one comment I have, and my colleague brought up the informational meeting we had from some of the companies that build the advanced core, the carbon core, and then the jack up the lines. And that was I thought a really good informational meeting, but afterwards we received some other information from steel companies that made me feel remiss that the commission didn't have them in as well. So I think that there's still a lot of information out there on advanced technologies that we heard, specific interests that presented information. That was good information, but we didn't give the steel folks a chance to present their information. I think we were remiss about that. And I don't know if we want to as a commission, have them in as well. But I think there's more to the discussion than what we heard at the info meeting.
And if I might, let's say this bill passed, 10 years from now, there could be other technologies. So all of those would come before the legislature, before us at some point. So I don't think they're going to tie themselves in right now to any one technology. So are there any other questions on Senate Bill 301? Commissioner Panochi.
Well, if we're going to make some comments on technology, I think that better follow up to explain that there
If
is.
I could, we're on questions on 301. We've had
Right,
my
well-
statement, her statement, your statement.
Then
Uh,
I should be able to make a statement, being that I've just had to listen to two that I think are incorrect.
Okay, if you could keep it short, and we'll move on to the other bill.
Core technology with the fiber optics inside the core is not available in the steel conductor at all. It's only in the carbon fiber. To be able to sense resistance, to be able to tell you where a branch is touching the line. Steel sags, steel will stretch. Carbon core does not. And steel does not have the technology to carry the information in the line to let you know the condition of the line. And that technology is what's in front of us and will cut fires by more than probably 60, 70%. And the steel core technology does not exist to have any communication inside the core. So I just want to make that clear. The reason they weren't in the meeting is because they don't have the technology even available.
Trevor, on the fire remediation bill.
Okay, Mr. President, Commissioners, on to House Bill 490. This bill too, as we reported to you, did pass out of the House. We didn't give you this one today because I didn't anticipate discussion on this one again this soon. But I think the key to note is it was heavily amended. On our front, the commission is still the lead on approving or denying the mitigation plan. But there are now requirements for DNRC and the Montana Department of Emergency Services to also review that plan and provide comments to our evidentiary record on that plan in that process. So that was an idea that came about largely to try to take a stab at putting more of the state's existing expertise when it comes to these topics into the mix. So that is really the key change in the planning process. The other key is it is no longer a may, it is a shall. The utilities shall prepare and submit these plans now. Want to point out to you that it still exists, that the plan be submitted once, and then it's essentially a send the plan in every 2 years, not necessarily a full review of the plan. The plan just lives here at the commission. On the insurance side of this bill, there was some significant amendments to, and I won't quote, don't quote me too heavily. I won't claim to be a homeowner's insurance expert. But essentially the problem in adjusting the balance of liability and negligence in insurance discussions is this. Anytime you shift risk from the companies to a homeowner, you're opening yourself up to raising home insurance premiums on this end. So it's kind of the way they've been describing it as a metaphor that I kind of like. It's a classic situation in which if you poke one side of the balloon, the air is going to push out the other side of the balloon. Where this bill started, essentially, was by saying you won't apply strict liability to an energy company in the event that they start a fire, and then further adjusting the negligence standards in which a court would do a negligence test in one of these cases, making the burden higher on insurance companies if they had a plan and the plan was proved to have been filed or followed. The word I've learned in this process is the process of subrogation, in which a homeowner basically signs a business contract that says An insurance company will make them whole in the event of catastrophe. And through the principle of subrogation, the insurance company then has the right to pursue legal recovery of their costs on behalf of the homeowner. So essentially what the bill tried to do is make subrogation harder for the insurance companies. And they came out swinging and put amendments on this bill that, although they probably still don't like it and their standards are higher, they now have some significant loopholes. Loopholes is the wrong word, but significant leverage to recover damages, especially in the event of a bodily injury or death. That kind of exempts the higher standard at that point. And also some measures to try to protect that subrogation right for the insurance companies. And what we heard in testimony in those hearings is if you don't do that, you're going to end up with a situation much like what we're seeing currently in California, in which State Farm is currently trying to pull out of that insurance market for a couple reasons, but one being their rates are capped by the California Insurance Commissioner. And that massive fire is going to leave them in a spot in which they cannot likely recover all of their costs. So they're on the hook in the form of a, in layman's terms, business contract with their customers there. But going forward, they want to raise their rates already. And the California Insurance Commissioner is denying them that opportunity. So they've made the decision to just pick their ball up and go home. That's what you're dealing with in this bill. Although there is discussion of wildfire risk, obviously, in this bill, it's not necessarily a wildfire mitigation bill in the sense that maybe folks want you to think it is, other than the fact that they have to file a wildfire mitigation plan. That bill is headed to the Senate side. That's what we know about it to this point. And again, we brought this back because there was some want to discuss where this bill sits currently.
I have a question. Last time I looked at that, and it may have been amended since, I don't know. It was no longer just the PSC that was commenting on a utilities plan, but the Department of Emergency Response and DNRC. Is that still in the bill as passed out of House?
Yep, correct. So essentially the proceeding happens here, and the Department of Natural Resources and Conservation and Montana DES analyze the plan and provide comment to us before you would make a decision up or down on the mitigation plan.
Thank you. Are there any other questions of Trevor on the House Bill 490?
Yes, Mr. President,
Commissioner.
thank you. Just to help me understand it better. So if the commission approves, and it is subject to commission approval now, is that the way it's written?
Yep.
Okay, so the plan, if the commission approves the wildfire mitigation plan submitted by the utility, then how does that impact their liability exactly?
If they have an approved mitigation plan, they get special or different treatment in the form of, business liability law than they would currently. Currently, they're treated like every other business in the state.
Okay. So the idea seems to be that the commission would be examining whether the utility is performing proper due diligence to prevent its systems from causing fire. And if we find that they are, then that alleviates some of their liability, but not all of their liability. Is that correct?
I would characterize it somewhat differently, in that what the commission is examining is their plan. What is their mitigation plan? Does it include everything that's required in statute? And is it in the public interest? The
Okay.
commission in this bill is not particularly an enforcement wing in which the commission would show up on a fire and say, this is how it started, you know, that'll still be left to fire investigators and the process that exists in the aftermath of a fire. But no, the commission is not an enforcement or, in lay terms, a police force of what happens in a wildfire under this bill.
Okay, so I think it's improved with having DNRC and emergency services involved in the review and advice to the commission. It seems like then if the commission approves the plan, if the utility submits a sound, what we find to be a sound plan, or the commission that's seated at that time, whoever it may be, finds that the plan was sound, you're saying that the legislation would put them in a different category of liability exposure, so it reduces their liability exposure in some way?
Mr. President, Commissioner Fielder, to get to the heart of it, what it really does is it requires a court to hold different negligence standards that are more favorable to the utility than the insurer, where a normal business liability case, when you get into the negligence test, would probably be a little more even-handed to both parties.
Okay, is there any possibility that the commission's going to have to be part of those court proceedings? Or would that just be between the parties that would normally argue about commission or liability and recovery of costs and that type of thing?
Mr. President, Commissioner, again, not an attorney, just a policy wonk, but that's been my concern from the start of this bill. One, that it opens the door to litigation on the determination that the commission, i.e. the state, made. And then two, I would think that a plaintiff's attorney who is trying to recover costs would be looking at every detail of the record in the determination we've made and likely try to drag any relevant facts from that case into their case. But would certainly cede to an attorney.
Okay, I think we have an attorney about to move forward, so I'd love to hear our chief legal counsel's opinion on this to the extent that he can comment.
Thank you, President Molnar, Vice President Fielder. Would you mind repeating your question for me?
Sure. So what we were talking about here was the legislation appears to put should the commission find that the plan is prudent or whatever the standard is required by law and approve it, then if there is a fire caused by the utility that we regulate, when the ensuing battles happen between impacted parties and the utility or whoever may be involved in litigation over those damages, my question was whether the commission would find itself in the middle of that litigation and have to be engaging at that level, or if we simply review and decide to approve or disapprove the plan, and then we're finished with it.
So, Mr. President and Vice President Fielder, I think 2 points that I'd like to make on this. First is the commission's approval would be subject to the normal MAPA process for a petition for judicial review. So to the extent that's litigation that you would be concerned about, that remains a possibility as with any other contested case. To your point, though, about whether or not the commission would be vulnerable to lawsuit or liability surrounding the prudency, I guess, of the commission's own action and its potential liability in an eventual suit seeking damages for the loss of property resulting from a wildfire, I would say that there are really 2 subpoints that I'd like to make. First is that I can't guarantee that the commission would not be named as a defendant in any lawsuit. Whether or not naming the commission means the commission is also going to be eventually liable for damages is a second question that I would prefer to take some time to research in the first instance and then present an opinion to the commission in a forum where we would be able to preserve the attorney-client privilege. If I render that sort of opinion in a public business meeting, that could be used whatever the opinion is, against the commission in future legal proceedings. So I think it would be best to carry on that discussion on a one-on-one basis.
That's fine. I'm just trying to kind of get a handle on, I understand the MAPPA process and, you know, the review process and the commission approval or disapproval process of filing made to the commission. And sometimes people appeal those filings and we end up having to defend our decision in court. I was just wondering to the extent of what else happens with this as far as us being in court, whether we're named in a case or we're brought in as witnesses or what it may be. I'd like to look ahead and see how this might entangle the agency in those litigation proceedings or potentially pretty big proceedings. Thank you.
I'm going to jump into the question here. I'm going to follow up on what Commissioner Fielder was talking about. So if we get named and the allegation is made that we didn't look at something, car leaves the mountain at 90 miles an hour and goes 300 yards down the mountain and hits a substation, starts a fire. Why didn't you harden that or request they be hardened? Any number of things can happen. Not only is it possible, from what you said, that the commission would be brought in. So is it our budget or would it be state budget? And B, could ratepayers be brought in to cover damages under the current wording of House Bill 490?
Mr. President, to the first part of your question about whether or not the commission or the state of Montana would be the proper party to be named, or the party liable for paying damages in the eventuality where the court concluded the commission or the state of Montana had done something negligent in the process of reviewing a wildfire mitigation plan. Again, that's the sort of question that I would prefer to research first and then render an opinion in a forum where we can preserve the attorney-client privilege, because depending on what my research reveals, that could be used against the commission or the state of Montana in a future proceeding. So I'd want to be careful about answering that question directly today in an open meeting. Second, on the question of whether or not ratepayers would be made liable, I don't know that I have a clean answer for that right now. The commission budget is paid for through the PSC tax, which is levied on all ratepayers. So to the extent that the commission were liable for any sort of judgment or damages, it would be up to the legislature to decide whether that comes out of the Public Service Commission's normal budget, or if there needs to be some sort of special appropriation to the commission to pay for some potential future liability. I couldn't say right now exactly how that would pan out in the future. It also remains to be seen whether or not the proper party in interest would actually be the state of Montana instead of the Public Service Commission individually. And because the state of Montana would be named, then it would be a matter handled by the Risk Management and Tort Defense Division, potentially through the Department of Administration, or potentially through the Department of Justice. There are a number of possibilities that would need to be worked out based on the circumstances of the claims made.
This may also go to your request to send something out with a client attorney privilege. But would it be of any benefit to the commission or the ratepayers to have an indemnity clause in the legislation that we are not liable because all we did was give a comment? We weren't really in charge of making sure that certain things were done. Or is that as easily pierced as what I'm seeing the veil is currently?
So, Mr. President, I would say that the concept that you're referring to there is the state sovereign immunity, which exists and can also be waived by the Montana legislature, and to a certain extent is waived by the Montana Constitution. Again, to answer that question, I would prefer to conduct some additional legal research and give you an opinion through the attorney-client privilege about to what extent any additional preservation of sovereign immunity would be appropriate in legislation like this, or if the legislation is fine without an additional preservation of sovereign immunity because it exists inherently in this sort of proceeding.
Okay, I think that perhaps the three of us should get together and discuss whether or not an amendment of simply putting that into the statute, never mind inherently, it's there. That can easily be referenced without a second argument as to whether or not that is prudent and something that we might want to all weigh in on as an amendment. Commissioner?
Thank you, Mr. President. Just can we get a recap, Trevor, on where these two bills are at right now?
Mr. President, Commissioner, Senate Bill 301 is currently in Senate Finance and Claims. Yesterday, the want was to have a couple days to bring that new amendment. House Bill 490 has passed through the House, and I have not seen where it landed as a committee assignment. I'm guessing Senate Judiciary. It's certainly not scheduled yet. So,
And how did it come through the House? Was it a pretty big vote in favor of it, or was it close? Or
I would have to look at my vote counts. It was in House Judiciary. It was a very long and lively discussion.
I was wondering about the floor debate, how it came through.
You'll give me just a second here.
I thought I heard it came off with really high numbers.
It did. I don't want to quote you wrong, though. So in due diligence, House Bill 490 came off the House floor with a 98-0 vote. So 98-1 vote, excuse me.
Thank you.
Commissioner Panochi?
All right, here's a good place to start. The reason this bill exists is so that the utilities can get out of liability to a greater degree than they do now. Is that correct?
Mr. Chair, or Mr. President, Commissioner, I don't want to speak for the utility, but it certainly gives different treatment to the utility than any other business in this state.
So let's say that we see what happened in California for the past few years. We've had several large fires over the last 8-9 years, and it's been in the billions of dollars. The insurance companies are raising the rates and the utilities are getting nervous. So they're saying, look, let's come up with a bill that gets us out of liability. Now, when they do that, it's going to fall on the ratepayer. Would you say that's a pretty fair assumption?
Mr. President, Commissioner, I think you heard from Lucas a little bit ago. It kind of depends.
Well, I've reached out to our state auditor's office. And what's interesting is President Jim Brown was president when he was here, and he has the experience of working on the commission, and now he's dealing with this bill, which, in my opinion, is designed for the liability to the utility to be less than it is. That's exactly what the design of this thing is. And as a commission in charge of safe, reliable, and affordable, and we're supposed to look out for the ratepayer, this is a really important time for us to focus on this very carefully. In section 2, it says, electric facility providers wildfire mitigation plan approval. We're going to be part of that process. And what's interesting is I held a special hearing to reduce fire risk, exactly fitting section 2. All right. The whole point was to say new technology exists to where we can monitor the temperature inside of a line. No conductor can do that. 2 or 3 companies are saying they can do it, and it's out, and they're producing it. Steel core industry can't do it at all. All right. So the whole point was we can reduce fire risk dramatically. We brought the specialist in. We can modify the structures. We can put up the line. We can cut line loss and lower the temperature in the line. Lowering the temperature is so important. So now, number 2, a wildfire mitigation plan must include a description of what are we doing here? We're trying to say if we're going to lower fire risk, here's some things we're going to do. We talk a little bit about vegetation. I've been working on this for years while I've been in this commission. I've argued with the forest industry that the trees have to be far away from the line, far enough so if a tree is to fall, it won't hit the line. Now, the National Forest tells me, well, that looks ugly. Well, it certainly may look ugly, but if we burn the whole forest down, you'll wish that tree couldn't have hit the line. So what we could do is say, we've got to get that path wider. Okay, now we run into homeowner issues, and let me explain. And I got a question for you on this. Northwestern Energy goes to the homeowner and says, we have to get on your property and cut the tree. It's too close to the line. The homeowner says, nope, that's my private property. You can't do that. Well, then I think we need to detail here, if the private property owner is not going to allow them to trim the tree, if the fire starts with their tree, then liability falls on them. We really, I want to help the utility do their job here, where if the landowner isn't going to work with them, and keep in mind, we have landowners that can have lots of forested areas. Should we be working on some of these questions with this bill now, being that we're going to be part of the approval process on reducing fire risk? What's your thoughts?
Mr. President, what you should and shouldn't do is the prerogative of the commission. However, there is some treatment of if a landowner does not let them into their property, they're not liable in this bill.
And that's exactly what I was talking about.
Yeah.
These issues we're going to be deciding on. So if we want to say you're going to get out of a little bit of liability, and that's the purpose, then show me that you're going to raise the standard to where the line is going to meet these new standards, where it's twice the strength, which is going to cut our fires dramatically, twice the strength, because carbon fiber is twice the strength of steel. We have the ability to have fiber optics inside that core to tell us where a branch is touching the line. So we're able to go out and cut that branch because we can sense it. We can sense where a bird's nest is being built. No steel core conductor can do that. They don't have the technology. They don't have the ability to sense that. If we make that requirement to say, if you want to get out of a little bit of liability, then please raise the standards. So all new lines installed from 30 kV up, we're picking 30 kV because it's difficult to put this new technology in lines that are under 30 kV, have to meet these new standards. And the industry was here explaining if we modify the structures, the power poles can be lifted higher out of the vegetation, they can be strengthened. Remember, when a power pole breaks due to wind, then the line can hit the ground, start the fire, and then there's liability. If we strengthen that structure or start inspecting them more often. Here's a story that we got to deal with. A few years back, somebody explained to me that we're not replacing our poles as often as we should because when the storm comes in, the insurance covers it, and that saves the utility money. So the utility maybe isn't replacing that. Maybe we could set the standards that more inspections have to be done to lower the fire risk. If you're going to say that we are going to do wildfire mitigation and this commission's going to approve it, I think that, well, we need to be involved in saying, look, if you're not going to raise the standards and let me play a role in that, then I don't want to approve it. Or do you think it's okay for us to say that and make that request to the legislation?
Mr. President, Commissioners, that's prerogative of policymakers. Whether it be a request of you all to the legislature or the legislature passing a bill.
All right, let me ask this. Should the Public Service Commission be able to assess a fine? Now, I don't want to be out there doing the investigation. We'll let the investigators handle that. But if the investigators come back and say they didn't meet these new standards in Section 2, can the Public Service Commission assess a fine, $100,000, $200,000? We have some teeth in the game to say, look, if you're going to put us on the spot to be part of reducing fire risk, okay, and I've been working on this for years, then what about the idea of us assessing a fine if they don't follow the very instructions inside this? Otherwise, what's the point? There's no punishment if they don't follow the new fire risk mitigation. If they break the rules, there's no consequences. How about we have the ability to assess a fine so that there are consequences to the action? What do you think?
Mr. President, Commissioner, I think I see the line of questioning you're going down here, and I think what I would tell you is, one, those things don't exist in this bill. Two, this bill is kind of a carrot approach where they file this plan, and if they follow it, they get the special treatment for liability. To the rest of it, it really is the prerogative of policymakers. Can you do that? Yes, you could. Could you enact a fine as a legislature? You can. Can you enact higher standards as a legislature? You can. But those are questions that I think are probably better put to your fellow commissioners and legislators, rather than me saying this is a good idea or a bad idea, or you should do this or do that. I don't think that's what you've necessarily hired me to do. I think all of those things are functional. All of those things could be in the bill. But again, it's the prerogative of the commissioners. It's the prerogative of the legislature finally, and making that decision and amending any of those things into this bill.
All right, well, I'd like to make a motion that we have the ability to assess a fine, that we have to play a key role in what our responsibility is in section 2. It says here, a wildfire mitigation plan must include a description of. I think that the Public Service Commission should be involved with that, especially when they're trying to get out of risk to what the liability is in insurance, which is the reason this bill even exists, because they're getting nervous because insurance companies are raising the rates. Insurance companies are actually pulling away from utilities. And I have been working on ideas to reduce fire risk with real answers for years.
Mr. President, just to help the commissioner with the point of order here, if you're going to make a motion, state it clearly so it can be recorded and we know what the motion is and we can consider a second. If there's a second, then we can have discussion. But if you want to make a motion, you need to do it properly.
Well, I'm working on that when you interrupted.
No, Commissioner, you're not. State your motion, and if there's a second,
I'm
we
trying
will
to
have
state the
discussion.
motion.
The motion needs to be stated clearly so it can be recorded by
I
the
don't
secretary.
think I was unclear with my motion.
Perhaps if you could state your motion without an argument in favor of the motion, I think that would be a bit more appropriate.
All right, well, I was interrupted. So I'm making a motion that we have to be involved with setting clearly what we have in section 2. And I want to be able to assess a fine and be able to be involved with new standards so we can actually reduce fire risk instead of just saying we got a bill that says there's going to be, a fire risk. Let's have some real answers to it. So that's my motion.
So to be clear, your motion is that we would present an amendment to this bill that covers those issues.
Yes.
Thank you. We have a motion. Is there a second? Is there a second? Hearing none. Is there any other further concerns to discuss on House Bill 490? If not, I have one. Hopefully it's the last one. I still have concerns that we, as I believe Trevor described us to the legislature, we're a bunch of attorneys and accountants. We're not wildfire behavioral experts. That's still true. I think that'll be true no matter what this bill says. So with that, between now and perhaps the next time this bill comes up, I don't know that it's scheduled anytime soon. If we could work together to consider that we should be removed from the bill, that takes care of a lot of liability, or B, that we comment to DNRC or emergency services, not they comment to us. So the final decision is in the hands of people with far more expertise than us. So with that as a coming consideration, I don't believe that we have any public or upcoming meetings or special PSC events that the public needs to be reminded about. So the date of the next business meeting is scheduled for the 25th of March at 11 a.m. Seeing nothing else to come before the commission, I adjourn. This meeting is adjourned.
I was just checking my calendar.
Oh,
It was the 26th.
really?
You got it.
I had 7 to 8. And I freaking. That's yours. Thank you so much. Yes, yes, thank you. And I'll have hers do it in big print like yours. It helps my old papers out a lot. Oop, oop.